For pronouncement of judgment, item 1 and 2.
Both appeals have been allowed. We have given the reason why the single judge's judgment is unsustainable.
Highly official.
Express different views.
That is Rajasthan High Court.
Rajasthan High Court. So, my lord, let's see in other High Court, my lord, some of the High Court cases are pending, but all the High Courts, my lord, is on single bench judgment, not in refer to the even division bench.
No, there is, I think so, that Allahabad High Court is division bench judgment.
Allahabad High Court, my lord.
Yes,
That Allahabad High Court judgment, yes.
that is a division bench judgment. 6th of August 2024.
But that I have mentioned here, I got the reference, but I yet to get the judgment, my lord.
Judgment note down 2024 SCC online.
Not reference had me, I know, man. Yes, that is reference is there, but I,
Oh, okay, we'll provide you.
yes, my lord.
We'll provide you.
I'll,
Any other,
I need-
advocate
notice issued, my
wants to-
Lordship, we have to receive the copy, Lordship.
Which copy?
This petition, Lordship.
Petition, it's a reference.
Reference.
Okay, we'll provide you. Any other advocate wants to?
Let's see, my lord, state of Assam, state of Mizoram, state of Nagaland, state of Arunachal Pradesh. Others, my lord. All right, your lordship, kindly issue notice, my lord, I will inform them, my lord.
And Lordship, our names may also be reflected, Lordship, in the cause list.
Issue notice. Issue notice to the learned advocate generals of state of Assam, Nagaland, Arunachal and Mizoram. Mr. Segia. Reference, there is a reference. Reference here.
Lordship,
So you have to assist the court.
no problem, Lordship.
Mr. D. Segia. Then counsel. Accept notice on behalf of the London Advocate General accept notice on behalf of the state of Assam. The notices be sent to the respective Advocate Generals of the state of Arunachal, state of Nagaland, state of Mizoram. Returnable.
Assam High Court of judgment.
22nd of October 2024. Mr. So-and-so, you are appearing for?
For the state of Arunachal Pradesh,
You are appearing for the state of Arunachal.
Lordship.
In the LinkedIn. So it's accept notice on behalf of so accept notice on behalf of the court. Each notice is issued. And any other additional advocate general or something
Mizoram and Nagaland.
from these two states, Nagaland and
Mizoram.
From our side, we will inform, Lordship. We can inform.
SP Bhattacharjee is there for
Yeah, P.
state of Mizoram.
Mizoram.
Mr. So-and-so is that.
I'll inform, my lord.
Accept notice on behalf of the state of Mizoram and another for the state of
Nagaland.
MKT, Lordship.
MKT.
MKT.
Mr. So-and-so is directed to accept notice on behalf of the state of Nagaland. Stop services, this matter on 22nd of October 2024. This reference.
Diploma.
That day will decide this water.
My lord.
You just assist that.
Lordship.
My lord.
The paper book be supplied to the respective councils. by the registry within a period of 2 days.
Adjournment request, if any, from item number 1 to 6.
Maybe Lordship. Lordship, I beg to mention item number 6, 7, and 8, my lord.
Yeah.
Conducting counsel, Mr. B. Patel is out of station, my lord, only 1 week time may be granted.
Okay. 6, 7, and 8.
One of us not. 6, 7, and 8.
6, 7, and 8.
My lord.
We'll also fix a date.
Whether he's having some difficulty.
I was the counsel, one. of the-
Oh, sorry, man.
My lord.
Well, after vacation on 24th, man.
Okay.
24th of October.
Then,
Wait,
My-
March. only.
Much available.
24.
Lordship, mention item number 5, my lord.
5.
5, my lord, written by the state, where we had alleged forgery while getting the repetition disposed. Now, this matter was again reopened in the trial court. The trial is going on the issue of the forgery. The next date is fixed on 27th of September for further evidence. Perhaps at this stage, we'll have to get some result from the trial court to
But,
establish at
it is-
least there was a forgery.
I'm appealing for the sole respondent law. I'm a legal aid counsel here. Here, the allegation that they have pointed against me is this, that I created some false document to confirm my regulation. Now, in that respect, Lordship, there was a FIR registered against me and which culminated into a charge sheet. And in that case, trial is going on before the CGM Tinsukia. So I just have a concern with my brother that this will be perhaps a premature stage.
Trial is at what stage?
2 witnesses have already been examined. Further-
PWs.
PWs.
9 of them, 9 of them.
Final report. It will be even moving for project.
After puja vacation.
After PW. Development.
Obliged.
At the request of non consent for that. After puja. Yes.
2020, 15 to bit of my 2020, 15 accessible, a little bit of my.
Obliged.
Any other request? Supplementary list for orders item 13 and 14.
May I please your lordship? Lordship, as per the instruction of the petitioner, the matter may kindly be withdrawn with liberty to file a fresh lordship.
I have no objection.
In council and matter comes upon.
13.
Then council for in both the petition?
No.
Only 13 lordship,
Only 30.
only 13.
Okay, PL number 50/2024. Then council for the submitted on instructions that he wants to withdraw a PL petition with liberty to file fresh. Dismiss then council, Mr. P. Sekel and the Advocate General has no objection. If the petitioner is permitted to withdraw PL petition, hence this PL petition is dismissed as withdrawn.
Deeply obliged.
But then,
In the connecting case,
connecting case will list it after.
yes, I mean, I have received instruction, we will pay for 2 weeks time to file it.
We collected another 46 of 2020. So this secretary is appearing on behalf of the London, Advocate General is appearing on behalf of the
State respondent.
all the respondents.
Yes.
So he pays some time to file counter to the petition time period for his granted response.
Highly obliged.
Who's available?
Daily list for hearing item 1 to 3.
So the
What
point
happened
is,
in the Supreme Court?
Supreme Court, it is 20th November, it is fixed, my lord. I am just giving a fix.
I'm bringing it in the. But they don't. case pending. Pending. Because of them, we हम लोग का यहाँ पे जब तो उलाइसी में 2013 को then confident it. This is the judgment that has gone up to the case. Really, and it's been. Still land are very fine.
You can conflict with the party. And submitted the issue regarding the applicability of the land revenue on the land acquired by the corporation is pending consideration before the Honorable Supreme Court. In civil appeal number so and so state of missing on the sheet dated 30th of March 2023. It is submitted that the next day before the Honorable Supreme Court in the above civil appeal in above reference civil appeal is 20th of November 2024. Stop. Give the fact that the issue involved in this petition is pending consideration before the Honorable Supreme Court. We deem it appropriate to list to adjourn this matter till second week of December 2025. These matters obliged.
Item 4.
My senior is on legs in court number 17.
In this matter, I was unable to obtain any instruction from the respondent, multiple short time.
It's a hearing matter. We can't do anything on that. If you are not, there's no instructions, we'll proceed. It's part of what else to be.
In the morning, I did not get the opportunity to take consent from the other counsel, so I did not mention.
Pass over for the timing. If you complete your own, we'll pass it over for the timing.
Before that, once possible. Because of Supreme Court judgment.
Yes.
Item 9 to 12.
May I please, my lord? These are income tax appeals filed for 4 assessment years, 9, 10, 11, 12, 12, 13, 13, 14 and 14, 15. The tribunal has passed a consolidated order in all the appeals on 6th July 2022.
Yes.
And the background of the case is this, that the appellant received dividend income of 3 crore 70 lakhs. I may point out that the tribunal has considered the facts of assessment year 13-14 in deciding all the appeals. So in the assessment year 13-14, the assessee received dividend income of 3 crore 70 lakhs. The assessee suo motu under 14A disallowed 2 crore 25 lakhs as expenditure relating to the dividend income. The assessing officer enhanced it to 10 crores and thereby made an additional disallowance of 8 crore 36 lakhs. We took the matter before the learned CIT appeal. The CIT appeal decided the issue that let the disallowance be restricted to the extent of dividend income earned by the appellant. Against that, the department went in appeal before the tribunal. On the sole issue, and the sole ground was whether the CIT appeal was justified in restricting the expenditure relating to dividend income to the extent of 3 crore 70 lakhs. When the matter came in hearing in appeal before the tribunal, there was an amendment to the Income Tax Act by the Finance Act 2022, and an explanation was added. In the explanation, it was stated that in a case where there is no dividend income earned, any exempt income earned, then in that year also disallowance has to be made. My first submission before the tribunal was that in our case, it is not a nil exempt income. We have earned dividend income and we have computed the disallowance and we offered. So this explanation does not apply to us. The tribunal took the view that no, this amendment is retrospective in operation, and they applied this and confirmed the order of the assessing officer and reversed the order of the CIT. Your Honors, in the memorandum explaining the finance bill, it has been stated that this amendment will be applicable from 1/4/2022. That is assessment
again issue. They have
Yes.
issued again a clarification.
Earlier, it will not apply. In the meanwhile, Your Lordship, on 20th July, the Delhi High Court decides the issue after the passing of the tribunal order. The Delhi High Court holds that this amendment is prospective in operation. And since then, there are 3 high courts, including the Calcutta High Court and Madhya Pradesh High Court. Following that order, nobody has taken any adverse view till date. Now,
Whether these Delhi High Court orders are challenged before the Supreme Court?
yes, I'm that issue. Your Lordship, I have filed a synopsis of case laws in my
Yes.
previous hearing.
Yes.
Your Lordship, I will take you the third judgment at page 18, para 12. Your Honors, may I read?
Yes, sir.
Para 12.
This is again Delhi High Court.
Delhi High Court.
Yes.
The High Court notes, so far as question B pertaining to section 14A of the Act is concerned, Mr. Agarwal fairly concedes that the same is liable to be answered against the revenue in light of the decision rendered in CIT versus Era Infrastructure Limited. So the learned departmental representative before the Honorable High Court has conceded that this issue has to be decided against it. At item number 2, I have placed another judgment of the Delhi High Court in the case of ERA itself, where at page number 1, para 1, page 9. May I read, Your Lordship? Mr. Kumar, learned counsel appearing for the...
Just let us complete. Yes. Mr. Kumar,
Learned counsel appearing for the appellant draws our attention to the final judgment in inter partes in the case of ERA, and this again the issue that by quoting the entire judgment, the Delhi High Court decided against the revenue. And Your Lordship, at item 4, 5 and 6, I have placed Calcutta High Court judgments and Madhya Pradesh High Court judgments, which have followed ERA.
Yes.
Your Honors, one more thing. In the last hearing, Your Lordship, because we had filed an MA before the tribunal. And, yes,
MA for,
for, after the Delhi High Court judgment for rectification. That day I was not carrying that MA order. You wanted to see the tribunal order, how they have dealt error in that judgment. I am placing those orders before you.
those MAs have been decided now.
MAs have been decided, we came in appeal, your lordship dismissed that appeal, you said that you can argue in the main. Your lordship, I will take you to state at page 5.
Yes.
Para beginning with, so far as reliance placed by the learned counsel on the subsequent decision of the Honorable Delhi High Court in the case of Era Infrastructure Limited Supra is concerned, we note that the said decision of the Honorable High Court is subsequent to the order of the tribunal dated 6/7/2022, and since the decision of the Honorable Delhi High Court is a non-jurisdictional High Court, the same is not binding upon the tribunal. Your lordship, one more thing I will point out.
Same being next thing. Oh, the same being decision can be taken into consideration in the next.
Your lordship,
Yes.
I am placing this order of the tribunal where the same members had decided the issue before deciding my MA.
During that,
Yeah, I placed at page 10.
10.
Yes. Lordship, may I point out, this judgment order is dated 9/11/2022. And my MA order is dated January 23.
What he has held in.
Yes, may I read, your lordship? The DR has relied on the decision of the coordinate bench of the ITAT Guwahati in the case of ACIT versus Williamson Financial Services Limited, the appeal before your honors, reported in so and so. Both of us herein were party to the said decision. To submit that the said explanation under section 14A of the Act is retrospectively applicable. How they deal? Para 14. However, the AR has relied on the recent decision of the Honorable Delhi High Court in the case of PCIT versus Era Infrastructure Limited, wherein it has been held that the aforesaid explanation inserted to section 14A of the Act is applicable prospectively. Respectfully following the decision, they changed their view in 2022. And when my MA comes for hearing, they say that this is non-judicial High Court, we will not follow. Your lordship, the rule of precedence is that if there is a jurisdictional High Court, even after the passing of the order, there is an error in the order of the tribunal, for which I place reliance on the decision of the Honorable Supreme Court in Saurashtra.
I am for the respondent market. Actually, in fact, my lord, after this circular, my lord, that is the circular issued by CBDT, my lord, they have clarified that it is prospective in nature, my lord. Otherwise, my lord,
Where is that circular?
Yes, lordship, I placed in the paper book.
that is in the paper book, lordship, serial number 3, page 10. They have clarified, my lord. Board has clarified it is prospective.
Yes, page para 10 at page 6 to 7.
6, sir?
To 7 of my compilation of document.
No, no. Your compilation, 7.
Para 6 to 7, page 6 to 7.
Page
6 and 7.
6 and 7. From 6 it starts,
Short compilation.
Yes. Yes. Yes.
May I read, your lordship?
Yeah. Clarification, the 14A in the absence of example, doing so and so. This para 10, na?
Para 10.
Yes.
Clarification in respect of disallowance under section 14A in absence of any exempt income during the assessment year.
Yes.
Section 14A of the Act provides that no deduction shall be allowed in respect of expenditure incurred by the assessee in relation to income that does not form part of the total income as per the provisions of the Act, exempt income. Over the years, dispute had arisen in respect of the issue whether disallowance under section 14A of the Act can be made in cases where no exempt income has accrued, arisen, or received by the assessee during an assessment year. The Central Board of Direct Taxes by Circular number 5 of 2024 clarified that Rule 8D read with Section 14A of the Act provides for disallowance of expenditure even where taxpayer in a particular year has not earned any exempt income. However, still some courts have taken the view that there is no exempt income during the year, no disallowance under Section 14A of the Act can be made for that year. Such an interpretation is not in line with the intention of the legislature. To illustrate, if during the previous year an assessee incurs an expense of rupees 1 lakh to earn non-exempt income of rupees 1.5 lakhs, or also incurs an expense non-judicial MA. Some pictures from the High Court I will play should be passed.
Ultimately. That officer is always present. Today he is not present.
It's better to hear all those cases.
Absolutely, Lordship. Because it will take quite some time, Lordship, this matter. And because if all the cases are heard together, then Lordship.
Mostly they learned single judge, what I feel, I've exactly gone through the whole order, but it seems that reasons have not been supplied. First,
Opinion has not been formed.
opinion
Has not been formed.
That opinion has not been supplied also.
Yes.
That is there. Jurisdiction point is also there.
Jurisdiction, it has come in our favor. 7 issues were framed. And one very important issue
That whether the penalty
should be incorporated in
that.
that law has been very well settled after the passing of the learned single judge's judgment. It is required by the Supreme Court in a SEBI matter.
The show cause notice along with the show
Yes,
cause notice.
that we have to. If we do not put, then that is a flaw. It is just the reverse opinion given by the Honorable Supreme Court that we must.
Then essentially, we have to decide whether this opinion was formed or not. This is what the main.
Yes, Lordship. For that opinion, we place the records. Those records or note sheets were not deliberated in the judgment. Very clearly, there's a long drawn process from 2015 to 2021 regarding formation of the opinion. And it was also formed an opinion that before starting the proceedings against them, a remission scheme was also given to them. Few of them have opted for the remission scheme.
With multiple judgment again. There is no down to be.
Not And one very vital aspect was not considered by learned single judge, Lordship. The provisions of Rule 4, Sub-Rule 2. The learned single judge discussed Sub-Rule 1, Sub-Rule 3, but Sub-Rule 2 was totally ignored, or there was no discussion on that. बाकी के पैसे तो तुम्हारे पे होते हैं। हाँ? इसका एक जवाब देती हूँ।
Cannot be said. Cannot be. Yes, there are 50. are in agreement.
It's para 56 of the interim judgment. Or rather, if we go to this para 43,
40.
whether the opinion to be formed under rule 3, if an individual opinion in respect of the person is specified against whom the notice under rule 41 is to be issued, if yes, whether any such individual opinion has been formed. Now, in conclusion,
Yes, the issue number 2.
issue number 2. In conclusion,
In
the
fact,
judge-
issue number 2, yes, it has gone against us.
It is gone 54. Accordingly, we are in agreement with Dr. Shraf and senior counsel that the requirement of forming an opinion would be an opinion against the person specified against whom being contemplated, and such opinion would not be a broad-based opinion. Having arrived at where we take the note of the submission of land counsel appearing for the respondent shall be produce the record and refer to certain materials which shows that the board do not have material before it to form an opinion against the individual petitioner's noticee of the present. We are not expressing any view of adequacy or accuracy of the material in exercise of so. We are going into the aspect of matter. We leave it to the individual petition notice to take up with the authorities concerned question of adequacy and so on. At the same time, we are of the view, whatever material is being relied, referred by the respondent against the writ petition, such materials would have to be materials pertaining to a specific person and not broad based. We have perused the record produced by the SEBI in respect of opinion required to be formed. So the records produced contain material which may be basis for an opinion, but the records do not indicate that the formation of such an opinion by the respondent bill, the SEBI.
This is where the mistake crept in. Precisely, I have noted it, Lordship. This is where the mistake has taken place. Individually, everybody's case was considered and the so-called notice contained annexure A, B, and C. The reversal trade committed by the writ petitioner, Lordship, amounting to 29% under the provisions of reversal trade. That whole details was given to them.
So far as
And the opinion was formed through several notes from 2015 till 2021 by all the board members. And 3 categories were made. Even we have considered the persons who died because we found that illegalities were committed by about 1,400 persons or entities. The so-called notice itself will clarify everything, Lordship, in my humble submission. And those note sheets I have, Lordship. I have 2 extra copies also of the note sheets and all the proceedings. What ultimately went ahead for the starting of the inquiry. Prior to that, investigation was done.
And so far as regarding maintainability, you have raised that.
We have raised that has gone against us. I am not on that now. Because we have reached the intra-court appeal stage now. In fact, the law is that at the very outset, that issue has to be decided. Only flaw which I see, Lordship, in our case, the so-called notice was issued under 4. We should have mentioned 4.1 and 4.2 because 4.3 is another stage. If you read the whole notice, it is under 4.1 and 4.2 because under 4.3, the specific date has to be mentioned.
Mention of reference of a rule does not involve.
Absolutely, that is also settled law, Lordship. And when our counsel before the learned signature said this is a composite notice, that composite notice is in respect of 4.1 and 4.2. 4.3, 4.3, 4 up to 4.7 are different. And therefore, in the so-called notice itself, we have said that if we are not satisfied, we will proceed under 4.7. Expertise.
Proper opinion. Individual. यहाँ पे सारे की जजमेंट के ऊपर पैरामीटर
Yeah, we'll list all these things together.
Lord.
Give us the details.
And we'll give the copies also to them.
Yeah.
I'm told that they have not received the copies, so we'll give the copy to them also. The same issue, all the cases.
That's right. Only the, because the composite judgment is common judgment.
Common
Yeah.
judgment, Lordship.
Okay. Then it comes for the parties submitted. Then it is noticed that against the impugned judgment, as many as 9 writ appeals have been preferred on behalf of CB. However, however, except this appeal, other appeals have not been listed for here. Stop. Then it respective councils may furnish the list of the connected writ appeals during the course of the day. This writ appeal along with the connected writ appeals, details of which have been supplied by the council for the by the respective councils on
I'm praying for before the vacation, Lordship. There's some urgency on
prior
our
to
side.
vacation.
Before the vacation,
Before vacation.
if it is not inconvenient to the court.
Except that.
First week of,
Because there is only last week, September
Last
last week, there may be rushed for on
Yes.
account of puja.
and then immediately on reopening, Lordship.
24th,
24th, Lordship.
24th of October,
Lordship.
24th of, you please supply the details.
We have already prepared, Lordship. In fact, if I had started, I would have, if Lordship, I can give it right now, the details. That will be very convenient also.
24th.
24th. I'm giving the details also, the whole synopsis.
Possible meter, 4.
Highly obliged, Lord.
Gunojit, case number বলবে সিনপসিস নয় কেস নাম্বার বলছিল কথা বলো হ্যাঁ
Yes. You completed your instructions?
Lordship, I seek some time for instructions, Lordship, I have failed to. obtain.
Instructions, now it's a hearing matter.
Yes,
You are in contact with the your client.
I tried to contact this morning also, but actually he is outside, he is from outside Assam. So I could not contact him today. Therefore, but the issue here is there was a assessment proceeding pending. It is,
Again, they have reopened it, whether
Yes.
they can do it or not.
Yes, Lordship, in the order that was passed by the Honorable Division Bench on 16/6, but the short question of law, we have relied on a judgment. On 16/6, that will be our argument basically.
16/6/2023.
22.
This one. This 2003 SCC 501.
Yes, but
Oui.
we will fix this a short date, but I'll
Yes, what is your submission about this judgment? When the controversy is already settled by the Honorable Supreme Court bench,
Your Lordship, I am not aware with this judgment.
so you are for
Income tax.
income tax. You are ready
On
to
behalf of Mr. S.C. Kiat.
Where is Mr. Gayan?
He is on legs in court number 17.
Complete your instructions, we are passing it over for day only.
Deeply obliged.
Next hearing.
Deeply.
Listed on 19. 19th.
Much obliged.
Instructions by 19th. Complete your instructions by 9th.
Deeply obliged.